Thanks very much, Elizabeth. And fun fact, by way of introduction, Rick was on the hiring panel some 20 years ago, and that gave me my first job in court administration. And so,
big mistake.
Well, that's off to a good start. And as you can see, for the last 20 years, we've continued to work together. I've had the opportunity to work in Utah and in a number of other progressive states that are really committed to improving the way that we deliver justice to families. So we're going to talk a little bit more about that through the Family Justice Initiative. The name may be familiar to many of you. It may sound something like the Civil Justice Initiative. By just show of hands, do you know if your courts are involved in the Civil Justice Initiative in any way? Okay, all right. Seeing quite a number of hands, about 50%. And then in terms of the Family Justice Initiative, I happen to know because I've talked to a number of you. Some of our pilot jurisdictions are in the audience today, which I'm delighted by. Show of hands, who is currently working with the Family Justice Initiative? Okay, great, thank you. Rick?
No, I was just going to say Utah was, thank you, Alicia. Utah is one of the sort of incubators of the Civil Justice Initiative, and that has been sort of the model for the Family Justice Initiative. When the Civil Justice Initiative went forward, we specifically excluded family cases. I'm stuck in a corner. And by the way, a couple of folks asked me at the break if we were going to be talking about family cases in the context of juvenile court, and we're not for the most part. This is basically about divorce and the related kinds of cases. And so those cases were excluded from the Civil Justice Initiative, but the same principles apply. So things like proportionality are very important as we talk about, sort of the old ADR phrase of the right forum for the right fuss, or the fuss for the forum, whatever that phrase was. Same kind of thing. We're trying to apply the appropriate amount of resources to the appropriate cases to get a good result in the end.
That's right. And we'll have the opportunity to tell you a little bit more about the nuts and bolts of the Family Justice Initiative, and our partners that are supporting us, the Institute for the Advancement of the American Legal System, as well as the National Council of Juvenile and Family Court Judges and State Justice Institute. And this is probably the point where you start flipping through your NACM program looking for other sessions to attend to, because really, who wants to talk about the conflict that is inherent in family court? But it is a reality. And furthermore, as court professionals, it's likely your reality, because as we know, the conflict that the families are experiencing then comes into the courtroom, and it's something that we all have to deal with. And so through the Family Justice Initiative, the idea is, are there ways that we can help families that are really rapidly evolving? Our whole definition of family is transforming. And so we're going to explore some of the ways that that is impacting the courts, and then how courts can respond. Have you heard it referred to as pots and pans court? Certainly a phrase that I've heard. And the whole idea of it being where it's a place where people are arguing about the pots and pans and some of the minutiae of their daily lives. And so again, considering the different ways that we can work with that and make that a better experience, both for our families as well as for ourselves as court professionals, for our judges, et cetera.
And let me just add one thing about that, a reason that I hope that you are interested in this topic is because these are the very most difficult cases we have. And of course, these are the cases that your judges choose to hear, right? They're the first choice. They are? No? Yeah, no. No, these are not the ones that judges say, ooh, I have always wanted to spend my day listening to people argue about pots and pans. Right, and just one additional thing that I've paid attention to recently. I don't know if any of you saw in 2017 there was a study from the ABA on lawyer well-being, and CCJ, the chiefs, heard that presentation and paid attention to some of the principles involved in that study and applied them to judges. And so now we're talking in many states about judicial well-being. So these really heart-wrenching, tough kinds of cases are ones to which we really need to pay attention, because they affect the judges and you all, our staff, in those really tough cases. And we need to pay attention to things like the secondary and tertiary trauma that comes out of hearing the kinds of, about the kinds of abuse and really awful circumstances, and frankly just the constant low-level anxiety that is really different, I think, in divorce cases and divorce-related cases than it is in other, I mean, all courts are about conflict, but these are the kind of emotional, splitting the baby kinds of issues that are really tough for judges to hear. So it's another reason why I think this initiative is important, is because it affects our staff, it affects our judges, and ways in which we can reduce that trauma and stress for us and for the participants, obviously, I think are things that we need to pay attention to.
Yeah. Perfect segue. So I do have permission from Eugene Corral, who is the family court administrator for the amazing 11th Circuit Family Division in Miami. And Erica Ruiz is here and just gave a great session on family court services that you may want to check out. And he told me a story about the reason that this particular urban court had decided to take on innovations in family court. And certainly this is a court that has done a lot to address families. They've got an amazing self-help center, they have the family court services. And in taking on a pathways approach, he relayed a story to me where there was a father that came in and had just lit into one of their most experienced court managers. And so this court manager comes to him and he's shaking. He's been in the court for 14, 15 years. And so Eugene goes out to work with the party and talks to the dad, and it turns out that he's been denied access, doesn't know when he's going to see his kids again, and is just completely reached the end of his rope because he's hit a procedural barrier, doesn't know how to get past it. And so what Eugene relayed to me is, he said, if we can do one thing that helps to reduce some of the hurdles that people have to overcome so that they can move on with their lives, then we're doing our job. And then he said, and where is our compassion for families? We don't make it easy for them.
And how many of you are familiar with the concept of procedural justice or procedural fairness? Right, so that is obviously something that's sort of sweeping the court community. And I think that is applicable to this compassion notion as well, because people don't have trust in our court system in general, although more than legislators and whatnot, legislatures. But in family cases particularly, I think they just loathe the idea of coming to court and airing this dirty laundry and having these conversations. And I think the procedural justice concepts really can help us here, right? So people who want to feel heard, they want a forum that appears to be neutral, and they want to be treated fairly. So the sort of tenets of procedural justice and procedural fairness. I think we need to apply those procedures not only as judges and as court staff in our interactions, but I think from a systems perspective. Our system of resolving family disputes should embody those same principles of being perceived as fair and neutral and giving people voice. And when we do that, I think that as a system, we will have more trust and confidence from the public, and this sort of angst and awful experience that some people have hopefully can be lessened as well.
So Rick here is a member of the advisory committee that has been formed of the Conference of Chief Justices, the Conference of State Court Administrators, and they have overseen the creation of they've overseen the development of the landscape report that we're going to talk more about, the principles and the pathways.
And I think those principles and pathways, again, as I mentioned earlier, are sort of built on some of the notions of the original civil justice reform, but also the other things that I think we're talking about are some of the principles that apply in problem-solving courts, right? Like using evidence-based practices or evidence research, coming up with evidence-based practices, what really works, the procedural justice kinds of things that I talked about, and obviously to some extent the same kind of case management principles that we apply to other cases, but let's tailor them to these family cases, differentiated case management. I mean, just basic things like that. But I think our charge was to make those all apply to this, in some sense, unique set of cases.
So, as we know, resources can be really limited in the courts. Maybe even more so in family courts. There aren't a lot of federal opportunities when it comes to family court. So we have to be so targeted and considerate about whatever activity we engage in. We have to be sure that it's going to lead to some tangible result and some outcome. And so this is the theory of change. These are the activities that we intend to engage in order to lead to these short-term and longer-term impacts. So what we're looking at is developing greater opportunities for user interface, really maximizing, drawing from the jurisdictions that have done a great job at having court kiosks or having court-assisted forms that can help the parties walk through the processes. We want to look at other ways that we can provide legal representation through legal clinics, through self-help centers, and really want to be thoughtful about the data that we have available so that we know that what we're trying to do through our different actions, through our interventions, that's leading to the outcomes that we're expecting. So that the idea is that by doing these different things, by putting in place these different interventions, that judges and court staff are able to facilitate the provision of services to families. That will lead families to better understand the processes. That's intended so that families can be better equipped to navigate the legal processes. We'll talk about some of those hurdles in a second. So that families actually get the services and decrees that they need so they can move on with their lives, meaning that they spend less money on litigation, less time in court, and that they're more satisfied with the justice system and served more efficiently. Ultimately, the impact that we expect this to have is that there can be less time to disposition, that the cases can proceed in a more timely fashion. We want to see that there are less case events pre and post decree, not simply to reduce the number of times that families are in court, but because they're truly getting what they need when they come to court, that each court event can be a meaningful event. And that finally, that this leads to improved satisfaction by families, attorneys, by court professionals, and judges. And the reason that we put such a fine point on the satisfaction is for the reasons that we've articulated. That first of all, you know, there are a lot of families that will never have a complex civil litigation case, but there are a lot of people in the public that will never have that exposure to the court system. But we already know that 50, 60, 70% of the population is at some point going to go through a divorce. And if somebody doesn't personally go through a divorce, they're going to have a family member that is going through one. And so really, this does translate directly to public perceptions of justice. The other thing that we want to underscore is the fact that, as Rick was saying, you know, there aren't a lot of people clamoring to get into family court. And as a matter of fact, you know, there have been a lot of courts that are undergoing some pretty significant transition and some turnover, people retiring early, meaning that there are less experienced judges or court professionals there. So, you know, I mean, really, it is significant that what we do, what we put in place, that it should have an impact on people's satisfaction. We become public servants because we want to serve the public. And so hopefully this will allow people to get back to the job that they signed up for, to help families, to be able to do justice.
And all of those things really add up to, I mean, I think if we were to describe what good court administration is about in one phrase, it's kind of on the front of here. It's public trust and confidence, right? If the public has trust and confidence in the judiciary, then everything runs more smoothly. And if they don't, we're all in a serious predicament. And so all of these things really point to public trust and confidence. And the more of these best practices that we can employ, the more confidence that the public has that we're spending their tax dollars correctly and that we're treating them fairly, back to the procedural justice notions, all of those issues. So I think that's what all of this is really about.
Perfect. So as I'd mentioned earlier, SJI funded this 3-year project, and it's modeled after the Civil Justice Initiative. We are solidly into the bottom phase, phase 3, the implementation and evaluation. We have amazing partners that we're working with. Those of you that are familiar with the Civil Justice Initiative know that that was something that the Institute for the Advancement of the American Legal System and the National Council, or the National Center for State Courts worked on together. And we are working with ILES once again. And we also have the benefit of working with the National Council of Juvenile and Family Court Judges, which has been tremendous in terms of the expertise that they bring in working with children and families. So let's talk a little bit about, through this process, there were 3 different phases. There's phase 1, which is to, first of all, take a look at the landscape of domestic relations cases and consider what does case management look like for family cases now? What do our families look like? One thing that we do know is that they don't look like this, if they ever did. And the second phase was through the CCJ-COSCA committee, to develop the principles and to specify pathways for resolution of family justice cases. And then finally, take it into the pilot stage. So what we know from that phase 1 of our landscape study, and we have copies of that available for you, it looks a lot more like this than it does the concept that we may have had of the nuclear family, where families are much more fluid. They tend to marry a lot less, as we know from anecdote and from social media. They actually divorcing less. You may have noticed that your case loads are remaining constant, and your populations could actually be growing. And part of the theory of that is that people are choosing to not avail themselves of the court system, but to come up with their own agreements. Families, the whole never married population poses some special challenges. And you may notice that your paternity cases or other allocation of parental responsibility cases are increasing. So this is the landscape. We have this online. We have copies of it available for you. And in performing this study, we did limit our consideration to domestic relations cases, to paternity, never married cases. We did not focus on domestic violence as the originating case, even though we recognize that in many cases, or in many jurisdictions, a domestic violence case can in some way act as an informal divorce case. So these are the different jurisdictions. So we put out a letter to courts across the country, a lot of the sites that were involved in Civil Justice Initiative, and we said, are you willing to share your case management data? And these are the 11 sites that responded. We wanted 10, but we got 11. So you can see where they are across the country. Some interesting findings from this, and we'll talk more about this, but 70 to 80% of our parties are self-represented. Any surprises there? 40 to 50% of parties of families will go through a divorce in the United States. I have to say, though, those figures are those figures fluctuate a lot. It depends on the sources that you're looking at. And there are figures that say that second marriages are at about a 60% divorce rate, and that it increases with each subsequent marriage. What we have here are is the basic composition of the of the docket for divorce for family courts. And so you'll see that a lot of it is divorce, but then you also have custody and paternity there coming in about 25% combined. 9% other. It's a little bit difficult from the case management data that's currently available to us. Those are probably they are usually some variation of a custody or a paternity case. There are different courts that define things differently, could be guardianships, and then we also have 22% support and 23 civil protection orders. What we know from this, and this was a difficult one, of the 11 sites that provided us with data, and I will just drop a footnote and say that we requested a number of different case management elements when we requested the data, and even the courts that had the most complete data were not able to supply all of the data points. And that is one of the findings from the landscape study, is that our current case management systems have a hard time giving us the information that we need about how our cases are proceeding. Our case management systems are built for a different kind of case. So from this, we know that 76.5% of them came to judgment. It's a little bit hard to know whether or not that judgment we weren't able to determine from the data provided whether or not that judgment was actually more of a settlement agreement. We'll talk a little bit more about that. Half of our families have children, about 51%. The presence of children in a case does impact how long those cases proceed and how often those final orders are subsequently modified. I'm seeing some nods. The number of times that cases are reopened. So this one's sort of interesting. You can see a definite, so let's say that your final decree is entered in year 1, that's going to stay solid. There's not going to be too many modifications. Those numbers represent the number of times that they're reopened. Again, the caveat that this data is not, we weren't able to find out with the level of precision that we might like to, how often a specific case or how often cases were reopened. But we were able to pull and to draw some conclusions that, if a child is involved in the case, and that is represented by the white bar here, you can see that those cases are on the average and over the span of years, they're going to be, in some cases, almost twice as likely to reopen as cases without children. Any surprises? No. This one was a very surprising finding, and I think it's good in a way because I think it points out that there is pretty good opportunity for us to improve the way that we're working with families. The data that we have would indicate that upwards of 70%, that those are uncontested cases. Now, again, the caveat that the data is imperfect in that it doesn't tell us absolutely that these were uncontested cases. Those are, whether a case is considered uncontested is defined differently in different jurisdictions. But what this does tell us is that on average, our cases, our parties are coming to court with at least partial, and in some cases, full agreement about what they want to happen. Another interesting finding from the study, however, is that those uncontested cases are taking just as long to proceed through the system as the contested cases. And that's where the opportunity is. 72% of the cases indicated that the petitioner and/or respondent was self-represented. And talking to different, and that number varied among those 11 sites, and some of them were much more at the 80% mark. And as I've talked to jurisdictions across the country, these are numbers that resonate every single time. I have yet to come across a jurisdiction that has a number that's less than 50%, less than 60%. So what this means, if our parties are self-represented, and knowing what we know about the way that we do our banking now, knowing the way that we do our taxes, everything that we do, we have an expectation that our processes be automated and that we be able to do so from the comfort of our own living room.
Sure, and obviously the automation trend in the way that the new generations are choosing to interact with their government and with pretty much everything applied more than just in family cases. But if we're trying to really meet our customers, if you will, where they want to be met, we need to go through this process of continually doing this kind of a landscape and measuring what the issues are. 72%, one or both of the parties unrepresented, I think is certainly an increase over what it was even 5 years ago. Why is that? Some of that is certainly because they, in my states, we've done a better job of providing resources for self-represented litigants. And I think most states have done that. But to Alicia's other point about automation, I mean, as you know, we want to do everything on our phones now. So we have a project in Utah where we're doing online dispute resolution. We've taken small claims cases as an example, and we're doing the whole thing soup to nuts on a phone, so that you can go through the process of filing, serving, everything pretty much electronically, and then having the case resolved if need be, include intervention of a judge online. And some of that certainly has fiscal implications for us. It saves us time and money, but really it's about meeting the customers where they are. When they want to use automation, then I think we need to pay attention to it. I know my kid, just this last week, I'll get you 1 second, just this last week he called, yeah, I've got a leak in somewhere in the ceiling, my upstairs and downstairs, and I got to find it. I said, well, geez, my response is call a plumber. His response is hop on YouTube and find one of any number of directional sort of videos that tell you how to find a leak and how to fix it and which way to turn the turn the tape, and I mean, whatever it is, everything is on YouTube. You can find it. And so they expect to be able to come to a court website and find instructions on how to do anything and everything related to family cases or other. Yeah, did you?
My question is, does the study also take into consideration?
You're good.
Can you hear me?
Yeah.
Oh,
Maybe
consideration our client's socioeconomic status, because a lot of times they may be not as savvy online, just for that fact alone.
Yeah.
Does that study take into consideration that where they don't have the phones to do what you were talking about, or they don't have computers or printers at home,
Right.
and they
Thank you.
have a myriad of other issues, obviously, maybe involved in dependency court and whatnot, but.
Yeah, thank you. So the question being, does the study take into account socioeconomic factors and whether or not people have access to, to being able to, use computers to do forms and whatnot? And I would say that this particular study does not. However, I would point in the direction of Isles, who has done a lot of work and has a number of publications that talk about different interfaces and how to work with the public. And I would say that anecdotally, that going back to Rick's point, that people do have an expectation to be able to do things on their phone, and that there are a lot of courts that have been responsive to the fact that people may not have full access by creating self-help centers that have legal centers right there. A couple come to mind, certainly Florida, Massachusetts, a number of different courts
So
that have
I think that brings up a good point, and I don't disagree with you, although, I mean, certainly as a court administrator who has lots of criminal courts as well, you'd be amazed at how many times people have, completely indigent, they've got a cell phone. Somehow they find a way to have a cell phone. But I think the broader point is that means that we need to respond again to the whole purpose of having the landscape and finding out what our customers want and need is measuring the appropriate response so that you have an array of responses for them, so that we don't assume that they're all going to have a cell phone and want to do it that way, because people of my generation don't necessarily want to do it that way. It's sort of like when we started in Utah down the road of self-help years ago, we thought we had the greatest thing in the world. We had these self-help kiosks, which at the time were state of the art, right? We were number one, ahead of the curve, like Utah always is. We have these kiosks in public libraries, and people would go down there and they'd print off these forms, and they had everything you needed, right? Except that people went in and they'd print off the forms and they'd go through a stack of paper like that, and they'd fill out all kinds of stuff that they didn't need to, and they'd fill out the wrong stuff. And then we had our clerks and judges going and saying to us, please stop this, right? So it's hard to anticipate where technology is going to go, but I think the point here is that we need to measure what our clients and customers want and then try to anticipate, in terms of technology and other kinds of issues that we're going to talk about, what they want and need, and then provide an array of services that hopefully anticipates that and matches what all of them might need.
Thank you.
Rick, isn't the answer the fact that 100% of people can't use it is no reason not to make it available for the 85% who can?
Right. So the point is, just because everybody can't access something doesn't mean you don't do it for the ones who can. But again, that speaks to you need to have, obviously we still need clerks who are cheerful and smiling and helpful at a front desk for those people who want to come in. We have a self-help center that deals with folks not only with texts and emails, but phone calls. Whatever medium you want to use is what we should endeavor to provide, it seems to me. Yeah, thanks.
And I will point out that John Grecian here authored 10 ways, 18 ways, thank you.
I can only remember 10 of them though.
So I think I know from the responses around the room, but any surprises to the data that you saw in terms of the numbers of self-represented? No. In terms of the fact that families are really changing. They're a lot more, they move quite a bit more. They're a lot more multilingual, multicultural. And so being able to respond to that changing environment is the subject of what we're getting into in talking about pathways. So these are the documents that were produced, the principles of family justice reform.
Can I just interrupt? So I just want to step back and make sure everyone's tracking. So we did a landscape that was sort of an assessment, right, of the landscape of what the issues are, what these folks look like, that we're trying to help, what their issues might be. One document, separate document, the principles and the pathways. Right? Sorry.
Thank
just
you.
wanna...
No, that's perfect. And we started off talking about the fact that these principles, in a lot of ways, look like they have concepts that are familiar to problem-solving court approaches, to therapeutic justice approaches. These core concepts to involve and empower litigants rather than, trying to pretend that they don't exist, pretend that families don't want to represent themselves, to find ways that they actually can do that successfully, to provide information and assistance that will help people through the different stages, to give people the right assistance at the right time. It's not enough. We might like to be able to give a family a packet of forms and say, complete these and let us know how it goes. But it's much more of an environment where we do have to help people walk through, because that is what we expect ourselves when we're conducting any other form of business that we have in our lives. And it's also important that we implement the appropriate technology, as we just touched on. Anything else that you wanted to say there?
No, not there. Thanks.
Okay, let's talk about the pathways. The pathways were developed in consultation with the Civil Justice Initiative and have been validated. The idea of pathways came from Civil Justice Initiative, but then there have been a number of courts across the country that have started to implement what we would term a pathways or a triage approach. One approach that you may be familiar with, and we drew extensively from the study that was performed in Alaska, where they created the Early Resolution Program. And that's a program that takes a look at the vast majority of cases. And if we consider again that 70–80% of the cases that are filed in court, parties may have an agreement already in their minds, and it's just a matter of getting that memorialized. And so Alaska was really effective in creating this program where they could identify that 80%. And then through court staff, they would call up the parties and say, we've received your pleadings, both the petition and the response, and it looks like you might qualify for an early resolution program type of divorce. And, well, what is that? Well, that's where you come before the court, and we're going to have staff attorneys, or we're going to have volunteer attorneys that are available to help you with your forms. They can help you complete a child support worksheet and establish exactly where things need to go according to the guidelines. And then we can get your decree that exact same day. Does that sound good to you? And then parties, yeah, I'm not going to have to spend as much time in court. I'm not going to have to fight this out. And I'm not going to have to spend as much money. That sounds pretty good. And so Alaska was able to put that in place and then study it, and they found out that those cases actually did take less time and that parties were happier with the process. Mm-hmm. So that could easily be 70 to 80% of the caseload, and that's exciting, because if we're able to work with those cases in perhaps one, or maybe these are parties that don't have to come to court at all. And there are, Arizona has, or Maricopa County has a process by which families, can do everything online. So if that's the case, then that means that we can really turn our attention to the other pathways here. And so these sizes actually represent what the caseload might look like. What we hear about this last pathway, the judicial specialized. Now, those are cases that could involve a protection order. There could be dimensions of family violence. There could be a mental health issue that the family is working with. In other words, these are cases that really do need judicial attention and quickly. And so that might be what we hear from estimates are about 8 to 10% of the caseload, which means if you're following through on the math, then there are really only 20% of the cases where we need to be specific and consider what tailored services would look like. Is that a parenting coordination type of a program? Is that some type of a workshop where parties can get the information that they need? Is it some type of alternative dispute resolution in order to allow people to move through? Mm-hmm. This is just a little bit more of a breakdown of what the process and the case and the business flow could look like, so that when parties are first thinking about, looking like they're going to be filing for a divorce or for dissolution, they're gathering information online, perhaps they're talking to attorneys and getting some legal assistance, perhaps they're going to a court and they're able to access some type of a navigator person, and that person is able to guide them through the process. Oh, it sounds like you need to, go access the family court services, or it sounds like you need to get this paperwork, or, oh, you're having a hard time achieving service of process. Here's how you accomplish that. And these positions are becoming more and more prevalent across the country.
And for those of you that were just, if you're in this session, you might have been in the one before that talked about bringing these services into the court. That's kind of the same sort of notion, where you bring those ancillary services into the court to provide to folks instead of sending them away for some of those ancillary kinds of services.
Thank you. So then parties file. And at that point, the idea is that courts are able to help them with the preliminary requirements. It is amazing how many people really struggle with service of process. So being able to help them through that, being able to help them get the correct documents, have them fill out the parenting time worksheets, the child support worksheets, and then get them to the next stage where a court professional can lay eyes on the case and determine according to the case characteristics. And in the pathways document, it actually does define certain characteristics. Your jurisdiction can take that and modify it to your own needs. And then at that point, we can make a determination of which pathway is going to be most appropriate. That's not the only pathway they can ever be on for the rest of their lives. Obviously, there are going to be opportunities along the process to, again, reevaluate whether that continues to be the appropriate pathway for the family.
Does this look familiar? Is this what some of you have, or does it look completely unattainable? Where are we in terms of this kind of a model of triaging and targeting cases? I see some yeses and some, we've got one hand back there.
In Alberta, we recommended that they use a triage in front of the initial filing for these kinds of cases. Because the parties typically didn't know what kind of case to file, so we triaged it in front end. And we also hooked them into ADR and or mediation, depending on the nature of it. We hooked them into ADR and mediation, depending on the nature of the filing.
So go ahead, work it.
Yeah.
Anyway, that's the only difference between what you have and what we recommended for Alberta province, and they actually adopted it.
So would love to hear more about that, because what we have heard so often is that, how do you actually have the information pre-filing in order to make the determination of what characteristics are present? Do you want to say a word or two about that?
Yeah, what they shared with us is that the parties came in and they knew the problem. Based on the nature of the problem, they were able to better define what kind of filing they needed.
Okay. Okay.
So just for folks who couldn't hear the first part of the first comment, so is it in Canada?
Alberta.
Alberta province, yes.
Alberta, you see, everything, we should be learning from the Canadians in all parts of our lives. But they're gathering some of this information even pre-filing. As Alicia mentioned, that's the ideal. The difficulty is getting that information ahead of time. But I don't know if you're going to talk now or later about sort of the Alaska process, where it turns out there are things that you can ask early on that you would not necessarily think are predictive of where this is going to go, but are very predictive. But I think at this point we can really only gather those things at the time they interact with us, right? At the time they file something with us. You can do some things in terms of public education, certainly, but I think for the most part we have to wait for them to come to us and say, we have an issue, but at that very instant is when we need to start trying to collect and direct them in the direction they should go.
Yeah, and I'll just say really quickly, those 5 factors that Alaska has determined that are more, that would show that the case is more likely to tend towards an early resolution. Some of them are sort of intuitive, and then some you might not expect. So it was like the length of marriage. If it's a long marriage, then they found that it's more likely that the parties know they have a history of working together, so they know how cases are going to go, or they know how the circumstances of their life are going to go, so they're more likely to have pretty solid agreements, early resolution. If they have older children, same theory, that they've figured out how to weather the bumps along the road. If it was a short marriage, a really short marriage, that could also lead to an early resolution because there weren't that many issues to deal with, or there isn't that much property to deal with. That's another thing, that they don't have significant estates or property to divide. And then there's a 5th factor that I'm blanking on. I'll get back to you.
Is the dispute one that has an easy legal answer?
Thank you, John Grecian. That's exactly it. So they would take a look and they would see if it was something, so say for example, the parties are out of sync when it comes to something as like a child support worksheet. And that's something that, that has clear legal definitions of what the resolution should be. And so that was an issue that, again, that when the court professional is calling the families, they can say, oh, so I see that, you've got some disagreement here. Are you aware that there's this calculation that applies? So, question back here?
Yeah, I was just, the gentleman from Alberta, what did you find in doing that? Did you find a better outcome for the cases, a quicker outcome in doing that before? Triaging it before the filing?
I have to be candid about that. I'm a consultant, and they wanted us to come in and re-engineer their process, and they described the resources that they have, and that was the recommendation, and they ended up adopting it province-wide. Since then, I've not been back, so I can't tell you the outcome.
Okay.
But I think that also brings us to one other important point, is that as you make these changes, and we're going to talk about some of the potential obstacles and ways you can get around that, but hopefully you're going, okay, this makes sense, this is something maybe we want to try. One of the things, though, that we certainly hope you will do is to measure what's going on. What's going on now, what's going on after you make changes, so that, obviously that's what we're doing with our pilot programs. It's what we're doing in my own state of Utah, with one judge who participated in early conversations about this and just went off on his own and said, I'm going to do this. And I'll talk about that in a minute, about some of the results, but measuring the results is obviously very important so that we empirically know what the impact is of making these choices and implementing these pathways.
So in rapid fire style, we're going to go through what we've heard as some of the common questions that people have about implementing a pathways approach. And if we do so, then that'll give us the opportunity to respond to additional questions towards the end. So what we often hear about, well, why should I implement a pathways approach? Doesn't that mean that if I'm a judicial officer, I'm just going to get all of the horrible cases from here on out? And what we would...
Yes. Oh, I'm sorry.
Go ahead.
No, I was just being a smart aleck. No, but I think one of the things we've heard, again, a lot of my experience and interest has been with problem-solving courts. And one of the things we found with those judges is a lot of them were disillusioned by what it was like to be a judge, right? What that job was like. And so after they got into a problem-solving court context, they kind of went, oh, this is what I was hoping it was going to be. And you get a lot of job satisfaction from that. Well, in a similar vein, do we really want people with all of these experiences and 3 years of law school and the best and brightest and whoever is picked by the governor or whatever your selection process is? Yeah, I go to work every day and try to figure out if the exchange of the kids is going to be at McDonald's or at Grandma's. I mean, that's not the kind of thing that gives judicial officers or staff a feeling of a job well done at the end of the day necessarily. And so if we triage these cases and end up with only either quick, it requires a judicial officer to put his imprimatur on a document and then they're gone and the case is resolved and everybody's happy, or it's a trial, but the trial is about meaty issues. I was talking with got my court administrator from the small place where the judge is doing that now, And one of the comments that the judge said is, get almost no trials now, but the ones that I do are real trials and we know what the issues are. We know what the fight's about. We're not squabbling about all this other stuff. By the time I get a trial, it's a real trial and it's what I signed up to be a judge for. So I think that's an encouraging response for judges and for staff and administrators in response to why we should make these changes.
Excellent. Question number 2, or issue number 2. I don't have the staffing to do more case management, so I can't take somebody off of my front line and assign them the duties of taking a look at cases and determining characteristics. They don't have the training for that. And you know, I have a line that's out the door. I simply don't have the opportunity to do that. Your response?
Oh boy, there are a lot of responses to that one actually. We did a program years ago where we did little mini grants for our judicial districts, and it was just $30,000, which at the time was almost what it cost for a clerk, a judicial assistant, as we call them now. And we had one district that put in place basically this kind of a facilitator for domestic cases, a domestic case manager. So they took a court clerk that was doing regular line duty and said, okay, you're now a case manager and that's what you're going to do. And that person actually is still doing it after almost 20 years. Back to my earlier point, she thinks it's great, but we reallocated existing resources and that district is completely convinced that they have saved clerical time at the front end by having one person doing this kind of triage and scooching of the case along to the appropriate pathways. Other responses, when we did the civil justice reform, we took that as an opportunity. Now, granted, it was in conjunction with when we moved to e-filing. We took that as an opportunity to completely restructure our clerical offices so that now we have teams surrounding judges. Instead of front office and in court, we have teams, including case managers. Same number of folks. Actually, with e-filing, we have had a reduction of personnel. But if it's an opportunity to restructure, if that's what makes sense, and to create new opportunities for your existing staff to do something maybe more meaningful and to move the whole process along. And the third thing that I'd mention is technology. This is an opportunity for technology to be your friend. Our self-help, frontward-facing, it's online court assistance program. Allows you to do a whole bunch of things on the front end. This is what we morphed to after the kiosks with paper, right? Now we have a TurboTax-like thing, and many states are doing this now, where it just asks you questions and leads you down a decision tree, and at the end, you just are responding to questions and comes out the back end a fully fileable, appropriate document with the forms that you do need, not the ones that you don't need. And that also is an opportunity, I think we're finding, to collect some of this information on the front end. So some of this triage that your clerks are going to be doing can be done in an automated fashion so that he or she isn't sitting down with somebody gathering this data, but he or she has a case filing that has populated a screen in front of them that tells them 9 out of the 10 elements that we're looking for as we're trying to triage this case. So those are a few of the responses.
And in reality, all courts have some type of processes in place by which either a judge or a court professional or somebody is taking a look at the cases. There are processes for determining simplified cases, streamlined cases already. So these are not new ideas or new responsibilities that people are performing. Moving on to the next point, what about protection of victims? Let's just say that you're looking at some type of a streamlined process, and maybe some of you flinched a little bit at the thought of a case going to decree without even the benefit of having been in court. So, and this is a complex issue. When you're looking at protection of victims, certainly we need to make sure that the paperwork, if there are case characteristics that we're looking for, we need to make sure that we're not potentially putting people at greater risk by the information that we're capturing in these public records. The other issue, though, of, well, are you really just going to speed these people towards a decree without even having a judge that's there to supervise the case and make sure that everyone's protected? Well, we have consulted with family violence advocates that have said, in a lot of cases, people just want to get on with their lives. And it may be the safest thing for that individual to have a judicial decree so that they are able to move, they're able to do whatever it is in order to get away from the violent situation.
Because a lot of times, obviously, we see the court process used as part of that victimization dynamic. So it's absolutely something you need to pay attention to, and it is something that in the steering committee we've paid a lot of attention to and heard from the advocates. As you dig into the pathways and the principles documents, hopefully we've got it right, but it's something that we hope all of you will pay attention to as well.
Common issue that comes up, my community simply doesn't have these services. And in fact, heard it in the family services. We would love to be able to do all of these things for families, but we don't have the money for it. We don't have the professionals for it.
So I don't know how many of you were in the session prior to this in this room where we talked about the Costco white paper on rural courts. And really the theme there is the same, right? Whether it's rural or just understaffed, how do we use the limited resources we have? And I think it's just a matter of, to some extent, deciding you want to do it. This example that I gave you of the judge who kind of took it on himself, he's in Carbon County, Utah. They had 114 divorce filings last year. And this is not a big community, and this is not a place with all kinds of ancillary resources. This is, in fact, coal country, and everything's leaving. And so it's a very economically depressed area. But what that judge has found, even in this rural area, just by basically adopting the principles and the concepts that we're talking about here and using existing staff, Travis was kind enough to pull the numbers even just this morning, and the time to disposition on these cases went from 172 days down to 149. And if you look at the spikes, I think it tells you kind of what the impact of this kind of triage is. The time savings is like 60 to 90 days out. That's where if you apply some of these resources early, just a little bit, it's kind of the old ounce of prevention thing, you can resolve those cases. And the trials are still 5-6 months out, but there have only been, I think, 2 since, the judge that did it, when I talked to him a couple of months ago, he said, I haven't had a single one, not a single trial. These have all resolved in some way by applying some small amount of resources and guidance early. Now I understand there have been a couple, but again, the ones that have come to trial have been real cases with real issues that needed to be tried, needed a judge, appropriate use of those resources.
So we only have about 5 minutes left, and I want to make sure that we're able to tell you a little bit about what's going on with the pilot sites, what's going on with the community of practice, to provide you with some resources and to connect you up with your colleagues who have some great ideas about different ways to improve on our processes. So we'll just kind of quickly gloss over these next 2 common challenges that the bar will oppose whatever you put in place. That could be true, and some communities have a very strong bar community that really does not want to pursue these new ways, and certainly ways that are going to enable parties to represent themselves.
I get that it's easy to say, but I don't care what the bar thinks. I get it's easy to say that. These are public resources. You get judges who say, hey, the lawyers know how to try these cases, it's their case. Well, no, these are public resources. We all in this room have a fiduciary responsibility to spend those resources appropriately. And if we can demonstrate, because we're all keeping data and we're looking at these pilot sites, if we can demonstrate that we're saving time and money for our litigants and improving their perception and public trust and confidence, I don't care what the bar wants. They'll come along eventually.
And as a former family law attorney, I will also say that there are some good ones out there that would really like to be able to have more access to the courts in the cases that really need that.
Well, and I say that sort of facetiously because they end up, I think, eventually with the same level of satisfaction that the judges and the staff do. This is a more pleasant process for them. This is not just, you get initial resistance, as you do with any change, but I think you overcome that at a point in time.
And some of the pilots or some of the early studies that we've seen do show greater satisfaction by the parties. Linda.
I'm going to defend the bar here. And what I would say is that one of the problems that we have is the attorneys that want to proceed and try very difficult cases with valuation issues and closely held corporations and stock options and all of that. The courts are so clogged that they end up having to pay for justice. They end up having to buy an arbitrator or a special master. So what I would suggest is that the bar ultimately doesn't oppose this, Because if that can remove
Right.
those cases
Right.
that are clogging the docket, it's going to allow the difficult cases also to be heard within time standards. So I don't believe that's true.
Yeah. And just because we didn't have a mic and for the millions of viewers online. So the point was the bar is frustrated with congestion in the courts, and to the extent, and I think this speaks to sort of the public outreach. And I'm being a little facetious when I said, we don't care what they think, but we need to reach out to the bar and explain why we're doing this, why we're making these changes, and if they understand that this will allow for more access for the other cases that need judge time and staff time. I think that they will be, if not supportive, at least not opposed to it. Good point, thank you.
And the very last question that often comes up, can't tell you how many times I've heard this from a different court, is we have a brand new judge. So here's our brand new domestic judge who looks to be about 18. Yeah. And the change of judicial leadership in family court, that is a real thing. It's not uncommon for family court judges, presiding judges, to be on a 1 or a 2-year rotation. And under those circumstances, yeah, it is kind of a challenge to put new innovations in place.
Yeah. So because we're going to have change, we'll just never innovate in this area. Okay. No, I mean, it's the same as dealing with the bar. If you explain to folks this is going to be more satisfaction, better use of your time, I think it's not an acceptable excuse. Let me admit, this happened as we were looking for pilot sites in my state. As well, the presiding judge is going to change. Well, so what? Come on. This is an opportunity to shape the new person as soon as she gets out of high school. And we ought to take advantage of that opportunity, because otherwise we will never make changes in this area. You had a question?
I have actually found that when we have a new judge, a lot of times they are willing to try pilot programs.
That's right.
Right. Excellent comment. When we have new judges, I found this absolutely, I don't know, there was a marker like in about 2006, and all of the judges after that really are just sort of culturally different, and they are interested in problem-solving courts. What does the research say? What is a new project that I can undertake? If there's research that says this will be more effective, the newer judges are much more interested in this kind of innovation. It's a really interesting culture shift.
So just in our final moments here, just wanted to let you know about the website that has these different documents available. We also are working with 4 courts that have pretty amazing processes in place in working with families and are kind of known for that. We're working with Miami-Dade, who I've referenced. We're also working with Seattle, who has their self-help site, their forums, they have family case managers, have a lot in place. We have Magistrate Ergen from Cleveland, Ohio, that's with us, that has put in place different triage processes. And we also have Tucson, Arizona, and Ron Overholt from the court there that has a navigator process in place and is really known for trauma-informed practices. So these are 4 ideal sites to gather information from. We're going to be working with them, helping them to refine their theory of change, what they want to put in place, what they expect to see as the impacts from that. We will be engaging in both a process and an outcomes evaluation, so that in 1 year time, we will have some pretty solid information for all of you about what the actual impacts of this process have been. And like I'd said earlier, what we expect to see based on these processes that have been put in place in different courts across the country is we do expect to see that we'll be able to resolve cases in a timelier fashion, with being more responsive to the actual needs of families and resulting in greater satisfaction. So that is all that we have for you.
Except, did you get the last slide? The most important thing, I think, is this one. So, I go to lots of these conferences, you all do too. I think this is one, hopefully, where if you will get these documents, get the pathways, get the
Principles.
the principles, and
Landscape.
go back. The landscape. That's what I was thinking. Go back to your bench meetings. Go back to your staff meetings. Go back to your state court administrator, whoever it is, and have a conversation about this. Try to make these changes happen. If they make sense to you, and I think they do, I hope they do. Make it happen. That's what this is about. Leadership from all of us, and get it done.
And when you want the documents, here's our developing website that has those the reports that Rick referenced, and we'll also be gathering tools from all of you. We would love it if you can share with us what your successes have been in determining pathways, the tools that you use to get there, and then any results that you've been able to find from that. So really appreciate your attention, appreciate your contribution. Thank you.
Thank you.